I'm Jeff Krieger here with the Minnesota Association of Townships, and get the light on here so you can actually see me. Hope you all are having a good week, and so far it's Tuesday. If you didn't hear, we are expecting some snow flurries, I hear, the next couple of days, and amounting to possibly 20 inches of snow. So you may want to prepare for that if you haven't already. Just have a few things to announce. Excuse me, I should have muted myself before I open up my can of pop. But as always, please put your questions in the chat box, and I'll try to monitor that as we go along here. I do want just to talk briefly about legislation, transportation funding, always near and dear to all of our hearts. If just to remind you, we are looking at $40 million in additional funding that we're going after. We did have some good discussions, some good testimony that I was able to do in front of the House and also the Senate on that very issue. It definitely looks promising for us, and we're hearing from both sides of the aisle that they do want to help us. We've heard this on dance before, I know that, and but it definitely it seems to be singing a little different tune this time, and so we have a little bit more optimism going into this session with that. We did have LRIP funding. I testified last week, Wednesday, I believe, in front of the Senate committee on capital bonding, also in the House bonding as well. And where there's a file called, I think it's HF 669. It's a Safe Routes to School program, but in there, I think it's like page 23. It talks about LRIP, or Local Road Improvement Program. And so they're talking about funding $85 million into that. Again, that's one-time dollars. I have talked about in the wording, the language, it does have a carve out for townships of $6 million. So when I testified in both committees asking that be a floor, not a ceiling. And when I did talk to MnDOT or state aid regarding that, they have assured me that if the 85 million does go into the LRIP program, they will allocate the funds as they did back in 2021. If you recall, back in 2021, there's $80 million that were dedicated to LRIP, and townships got between 13 and $14 million of that. And so if 85 million goes into LRIP this year, I think we can definitely expect to get about $15 million of that dedicated just for townships. And again, if you recall, it's one-time funding. Those are for roads of regional significance. Well, we're townships. We don't have roads of regional significance, but that's why there's a carve out for townships and also for small cities. And where even though we don't really qualify under that line item, we still get small cities and townships share a third of the total LRIP funding. Counties get a third, big cities get a third, small cities and townships split a third. And unfortunately, last year, small cities actually got more of our third than what it wasn't split right down the middle. So hopefully this year it'll kind of flip flop, and maybe we'll get more this time. Annexation, we do have a bill that's being jacketed, and for annexation, it's going to be very similar to what we did last year with the Bruce Anderson bill. Actually, we combined Bruce Anderson's bill and Kiffmeyer's bill together, and have some negotiating terms in there. So if we need to, we can throw out. We have something to throw out. Basically, give them a bone kind of thing if we can get to that level. Because we have 70 new legislators that we have to educate on townships. We have talked to the chairs of state and local gov for both House and Senate, and it doesn't look very promising for us to do anything with it this year. People just don't have an appetite, and I mean this one is the same song and dance. We've been going around and around with this thing for over 3 decades, and ever since they changed everything in 1992. So we're still going to fight. We're still going to try and get some things changed, at least educate this year, with the hope of, because next year's a policy year, next year maybe we can make some inroads. But that will all, and this is my same song and dance that I've been saying to you guys for ever since I've been here 2 years. That I need your help. I need you guys to talk to your legislators, talk to the chairs, the committees chairs of these committees that are important to us, and we need to make our voices known and make our voices heard. Next thing we have is PILT, which is HF or House File 825. This one seems very promising as well. So right now, you townships that have PILT land in your townships, you know that after a while that pretty much the valuation goes down to nothing. And so of course you're getting paid, next to nothing on that land too. But if it was held in private hands, that land would still be of value and would still be getting a pretty penny for that as far as assessed value for that. And of course, you would then be getting your typical type of taxes on that, property taxes. That's what we're trying to get back to. So no matter who owns it, it shouldn't matter if it's public or private. The townships still have bills, counties still have bills. And so those things still need to be paid, and we still should get the proper assessed value for that. And of course, taxes on top of that. HERA, this is something I talked about last month. I got a little more information regarding it. And this one too has wide bipartisan support. So we're pretty optimistic about this. What this deal is that if some of you may not know this, but with PERA, and that is the public employee retirement account or something like that. And but if you are an elected official and you opt to go into PERA and participate in that, that's considered, that's one program. That is the contribution plan. And so there are two plans in PERA. If you are an appointed person, you're in what they call the coordinated plan or the benefits plan. So they're two completely separate things. The trouble comes is that once you were first elected officer, and now you're in the contribution plan, if you stop being an elected officer and say you become appointed, you have to stop contributing to the contribution plan and you have to go into the benefits plan. Well, if you want to stay with your contributions plan, because that's what you've been doing, say for 20, 30 years or whatever, you do not have that option right now. We're trying to make it so that you can have that option. That's really all the difference would be, is that if you want to stay with the plan, if you have a plan that you like, you can keep it, that kind of thing. So we want to make it so that you can keep your plan if you want to. Capital construction sales tax. This one is just for when you're building roads and doing all that kind of stuff. If your vendor, whoever's doing the purchasing of these products, if they're paying sales tax, obviously they have to pass it on to you, and then you'll get the refund, but you have to go through all the paperwork, all the rigmarole to get that refund back. And so here we're trying to streamline this and cut it off at the source. So when the vendor goes to buy the product or what have you, they won't have to pay the sales tax, and of course, then you won't be assessed the sales tax either. Broadband, House File 1564. That's also Senate File 1523 is the accompanying file for that. Essentially, all this file is, and we're in favor of this. It exempts fiber and conduit from sales tax. Theoretically, it should make the projects a little cheaper for us in the townships when we're having these things done. FMLA, I talked about this, Family Medical Leave Act. This is House File 2 and Senate File 2. Essentially, what this is where people can get up to 20, actually in some cases up to 36 weeks of paid leave. 24 weeks if I can't remember what all the criteria is, but 36 weeks if you're military or ex-military or whatever, what have you. So this could be a real killer for us townships. So far, there still is an amendment in the bill that exempts organizations that have 50 or fewer employees. Obviously, that's every township, so we're safe from that. But as they go into committee, and this gets laid over for inclusion in the omnibus bill, what have you, things can change when they're negotiating. So we want to make sure that we are watching closely to make sure that amendment stays with that bill, if that bill is going to be voted on and later passed potentially. County ag inspectors, essentially weed inspectors. They're just asking for more funding. This is House File 80 and Senate File 1312. And this is just asking for more funding so that we can get more ag inspectors, weed inspectors that can help out the townships and so forth. And speaking of helping out townships, Office of State Auditor, and she is, or OSA office, they're asking for it, and I don't have the bill number on this, but they're asking for one person to be dedicated strictly to townships. And if you're at the Township Day at the Capitol back on February 2nd is when she spoke, Julie Blaha spoke, she talked about this, and that we have currently over 200 townships, typically on an annual basis, that do not file their finances. And we have about 50 to 60 townships that have not filed multi-years financials. And Julie and I have had several coffees and discussed this thing. And she doesn't, and she's even said this on February 2nd at the Township Day to the township officers. She does not want to put teeth to this thing. She doesn't want to have a penalty, but it's getting to that point where she's going to have to start bringing out the stick, if you will. And for those townships that do not apply or do not submit their finances, there's going to have to be some type of penalty that's going to be assessed. What that is, I have no idea. I don't think she even knows at this point. I'm sure she has ideas. But anyways, so this is an attempt to hopefully stave off that stick. So they're hoping to get some additional funding so they can actually hire one person, again, dedicated strictly to townships to help you out with the finances should you need that. And with 200 townships, that will keep that person pretty busy. LRIP, we already talked about. Well, this is something that just came up. Goes to show sometimes how we at the lobby team, as a lobby team, can pivot when items come up. I talked with somebody from Avon Township, and they're off of I-94. And what had happened, I don't know how long ago this was. I think it's just recent. There's a sound barrier that was put up on the north side of I-94, and it's going up to St. Cloud. And the Avon, the city of Avon, is to the north of I-94. The township of Avon, or Avon Township, is to the south of I-94. Well, they put the barrier on the north side of I-94 to protect the city. They put nothing on the south side to protect the township from the noise. Well, what has resulted from this is that now that barrier on the north side has acted like a backboard for all the sound. And so now the township is not just getting the normal traffic noise, it's getting amplified traffic noise because of the sound reverberating off that backboard, that soundboard, and coming back into the township. And so it's really creating quite a difficulty with that. And just on a whim, I was talking with Scott Dibble, Senator Scott Dibble. He is chair of transportation. And I mentioned this to him, and lo and behold, he has this really stuck in his craw, so to speak. And he's not a big fan of MnDOT doing this type of thing, where they don't make it equal. And so right now, the way that the statute states is that any incorporated LGU, local government unit, can apply for a sound barrier. And now it's matching funds. It's not all paid for by MnDOT. So township is going to have to fork over some cash on this. And but what we're trying to do is get rid of that incorporated word, so that it'll be any LGU can apply for this. And again, it will be matching should they succeed in that. That's all I have for legislative stuff. I don't know if there are any questions to me. I'll get to the chat in just a little bit. I just want to finish what I have here. For Township Day, remember March 14th. I'm sure you all know that. Spring short courses start on March 20th. And again, we are going to be live in person, not taped, and to all 15 locations, 3 weeks straight. And so we're looking forward to that occurring. And just to give you a little, this is kind of pushing the envelope. I know we still have winter here, but I want to talk a little summer too, because in town law review on June 14th is coming. We don't have a venue yet. It's either going to be at Siegel or Burnsville, which it typically is. And but be on the lookout for that. I'm sure we'll have that. I know we'll have that in the Insider, the spring edition of the Insider magazine. So let me go to the chat. This way to support our ice rink. I have one, but the residents considering whether to accept. Okay, I'll leave that for Graham. That's what we go. Oh, okay, Graham already did that. Thank you, Graham. Appreciate that. I don't see any other questions. If anybody else have any questions at all, feel free to unmute yourself or write in the chat if you don't want to say it, or if you want to, just you can say your question later on too during our presentation here. And seeing nothing. Graham, are you there? I'm going to pass the baton over to you.
Hey, Jeff, I'm right here.
Perfect.
Thanks for the introduction. All right. So, good morning, everyone. So today I thought that I would finish up on the presentation that we started last week. That is on conflicts of interest. So let's go ahead and jump right in here. Just a moment. All righty. So everybody should be able to see my screen here.
That's great.
All right. So today we're going to be talking about conflicts of interest. Excuse me. Sorry about this, technical difficulties. All right. All right, then. So what you should be seeing is the slide here. I am hoping that I am avoiding showing my notes a little bit. Let's
Nope, we can just see that first slide, 2 major types.
okay. Oops. Sorry, guys. I apologize about this. I'm apparently having difficulty getting my my notes up at the same time as I'm getting the actual slides up. Okay, so you should be able to see the slide and not my notes. Hopefully this is working. We will see. All right. So relevant to township officers, there are 2 major types of conflicts of interest. There are statutory conflicts and there are common law conflicts. Today, I thought I would cover both, at least briefly. So first we're going to talk about statutory conflicts of interest. These come from 2 statutes, largely, Minnesota Statute 365.37 and Minnesota Statute 471.87. You'll see the text of them largely on your screen. So an officer is who is authorized to take part in making a contract is prohibited from having a direct or indirect personal financial interest in any payment, sale, lease, or contract with the town board or to benefit financially for one from one. Now, this is, of course, a very broad and sweeping prohibition against officers having any sort of financial interest in a matter that they're authorized to decide or control. There's no dollar threshold here. It applies to any contract, even $1. And the purpose of this prohibition, of course, is to protect supervisors from benefiting from a contract that they are authorized to decide on. The focus tends to be on those authorized officers authorized to vote. So as a practical matter, focuses tend to be on supervisors, but if you'll look at the language carefully, it talks about taking part in, not necessarily voting on. So arguably, clerks are potentially doing this when they're publishing or posting notices, when they're collecting quotes, when they're reviewing bids for compliance on the specifications. Now, there are not, as far as I'm aware, any actual cases of clerks being charged with a violation of this specific statute. Nevertheless, that language is a little bit broader than is traditionally understood. So one other implication of this is that the contract exists anytime that the author is, quote, authorized to take part in the making of the contract. It doesn't matter whether the officer didn't vote. It just matters that they are authorized. So of course, towns pay supervisors to do this sort of stuff all the time. All of us know as a purely practical matter, township government simply would not be viable without the extra work that officers do. So the legislature has acknowledged this and has created sort of these exemptions that a board can use to solve this problem potentially. We're going to talk about the two most important exemptions, or at least the most common ones that we see here at the association, that do allow the town board to pay officers to do stuff like, clear the roads, be road inspector, that kind of stuff. Now, the exceptions are listed in the full list is in Minnesota Statute 471.88, and there are a whole lot of them. But the most common are 471.88 subdivision 5 and subdivision 12. Now, subdivision 5 is probably the most common exemption that we see, and that allows an officer to, quote, enter a contract for which competitive bids are not required by law. Now, if you take a look over at the municipal contracting law, you'll see that sealed bids are not required unless the estimated amount of the contract is over $175,000. That means that an officer can get paid by the township, can contract with the township, if the board expects the contract price to be less than $175,000. If the board passes a specific resolution, that resolution is outlined in Minnesota Statute 471.89 subdivision 2. That is, it has to be authorized in advance. It has to set out the essential facts of the contract, and it has to state that the service can't be had for a better price. That is, the supervisor or the township officer is offering the item or the service or what have you for the same price or lower than it can otherwise be obtained. Now, the last piece is that the officer has to submit an affidavit in order to get paid, and that affidavit has to contain substantially the same recitation. So there's a few extra pieces. If you want to look this up yourself, the authority comes from Minnesota Statute 471.89 subdivision 3. And what that says is that the officer has to give their name, has to give their office, has to give an itemization of the commodity or the services that were furnished, the contract price, the reasonable value of the commodity or services furnished, the interest of the officer in the contract, and that to the best of the officer's knowledge and belief, the contract price is as low or lower than the price which the commodity or services could be obtained from other sources. Now, we do publish samples of these forms on our website, and if anybody would like to get a hold of that resolution, we have both the sample resolution and the sample affidavit. So if anybody would like to get a hold of that, please shoot me an email. I'd be happy to send you a copy. Otherwise, it's available on our website. Now, the other common exception comes from subdivision 12 of that same statute that we've been talking about. And you'll see the text of it here on your screen right now. Subdivision 12, an officer of government unit may contract with that unit to provide construction material or services or both when the sealed bid process is used and the local government unit has a population of 1,000 or less according to the last federal census. So this one's a little bit notable for the differences that it has. It's more flexible in terms of the dollar amount. There is no dollar amount that's necessary to satisfy this specific exemption. You can go as high as you want, but it's also notable for just how much more onerous it is. So if you go through the whole sealed bid process, which is quite a rigmarole, and an officer wins, the officer can't vote on that question of the contract, of course, but you can potentially use this, albeit though you do have to limit that to specifically, quote, construction materials or services or both. So there we are. All right. So moving on to the next sort of big area, you'll see our picture of a judge here. We have moved on from statutory law to common law. Now, unfortunately, this prohibition is a whole lot fuzzier than the very clear statutory conflicts of interest. So the second type of conflict of interest arises when the supervisor has a personal financial interest in the matter to be acted upon the board that is not a contract. When an officer has an interest in the matter, the officer is supposed to consider the following factors to decide whether or not they're disqualified from voting. So these are coming from Lenz versus Coon Creek Watershed District, which is a Minnesota Supreme Court case. And they have to consider the nature of the decision being made, and the nature of any financial or pecuniary interest, the number of officers who are making that decision who are interested, the need, if any, to have interested persons make the decision, and the other means available, such as the opportunity for review that serve to ensure that the officers will not act arbitrarily to further their selfish interest. Now, of course, this creates some difficulties here, right? Because theoretically, the decisions made by a township government affect every resident, and just as obviously, you can't be a board member without also being a resident. So how is it? So how is it that it's possible to not have a conflict of interest in this sense? Well, we take the view that these interests have to be greater than those shared by every other resident, because otherwise, obviously, township government would be quite literally impossible. You would have to be a resident while being prohibited from being a resident of the township, right? But of course, this is all a bit fuzzy. So as with anything dealing with sort of common law stuff, I think it's just a lot more helpful to talk through specific examples of what the courts have done when faced with these problems. So on this slide, you'll see a couple of fact patterns that we've picked out and that are examples of the courts applying these factors to specific fact patterns. Now, the one on your left is a case called Rowell versus the Board of Adjustment of the City of Moorhead. And in that case, a Lutheran church, Trinity Lutheran Church, obtained a zoning variance from the Board of Adjustment of the City of Moorhead. Mr. Rowell brought suit against the church and also the city to try to invalidate the action. And he argued, among other things, he had a lot of arguments, but one of the arguments that he made relevant to us was that the deciding vote granting that variance was cast by a financially contributing member of Trinity. So this city council member was a member of the church. He also financially contributed to the church. And so Mr. Rowell says, hey, that's no good. That's a conflict of interest. He should have been DQ'd. Now the court said this. Here, the nature of the pecuniary interest was such that it could not reasonably have influenced the voting board member. We agree that the board member had a non-pecuniary interest in the general welfare of Trinity. This interest, however, is not likely to be contrary to the interests of the general public. To disqualify city officials from matters in which their church has an interest would unnecessarily tie the hands of city agencies. City agencies would be particularly effective in smaller towns where the likelihood of a city official being a member of the local church is greater. Board members' membership in Trinity without evidence of closer connection is not sufficiently direct to justify setting aside Moorhead's action. Now, the case on the right there that you'll see is ETO versus Town of Marion. And basic fact pattern there is, so town board, so there's a tavern owner. He's applying for a renewal of a liquor license. Town board rejects him. The district court says, no, that rejection was no good. It was without legal effect because of conflict of interest reasons. The Court of Appeals reverses, and then because things are particularly aggressive in this area, the Supreme Court of Minnesota reversed again. The underlying issue is that one supervisor, so he lived kind of across the street from this tavern. He owned about 53 acres. And he said publicly that his property had been devalued by, quote, $100,000 since the bar opened. That guy was the critical vote denying the liquor license. And the Supreme Court held that so this is a direct quote. He was ineligible to vote. He has a direct, substantial, and flagrant conflict of interest. And so in discussing the lens factors, they say this decision was adjudicative in nature. The supervisor's pecuniary interest was large. I mean, he himself says it was $100,000. He was the only supervisor with such a conflict of interest, and there was no reason to require the official making the decision to have a personal interest in the outcome. Obviously, this stuff is pretty fuzzy. And these factors can be particularly difficult to apply and particularly complicated. So anytime that you guys are getting close to this, we recommend in the strongest possible terms that you consider seeking the advice of an attorney here. So Pat Simberg asks, on the tavern issue, does it matter how long that tavern had been getting the license? You said it was a renewal. It was a renewal. It was his first renewal. I don't think so. The Supreme Court didn't really talk about that in any depth. And in fact, they didn't really talk about the fact that it was a renewal versus a fresh license application. And here I should note that I think they're being a little bit loose with terminology. It wasn't really to the town board to approve or disapprove the licensure. The license was issued by the county, and the town board wasn't issuing the license. The town board was approving the license, which would then be issued by the county. But that's a nicety. That's a little bit afield of what we're talking about. No, I would say the critical thing is that this guy got on the record and said, I am going to lose $100,000 worth of value from my land if this license goes through. And then he voted to protect his own pecuniary interest. That, I think, was the center of the court's reasoning. But these factors are fuzzy, and specific advice about your specific situation, if you ever come close to something like this, is a really good idea, in my view. How did he determine that he would lose money or value on his land? So this is an interesting question. The court just sort of quotes him and takes him at his word there. To be honest, I find that a little bit dodgy in terms of the underlying facts. So they don't really talk about that in any detail. It seems to be that he thinks that this tavern is going to, there's going to be people driving there. There's going to be people. This is sort of a rural tavern, is my understanding, kind of out next to a field. And he just thinks that people are going to damage his land because they're near a bar that's kind of rowdy. So I don't think that he's probably right about that number. But the fact that he said it, the court took that as true. And that's kind of how they went with that. So. All right. Does anybody have any other questions here?
Thanks, Grant. Appreciate that. Yeah, if you guys have questions, just let us know. And yeah, I'm going to pass off to Heather in just a little bit. I have two more things to talk about that I just reminded myself of. One is we have a new bill tracker. So if you go to our website under the Legislative Center, and there's a bill tracker button on that page, and it'll have, and we'll try to keep that updated. And but it's an automatic update, and that the service does for us. But you can download it anytime that you want to take a look at all the bills that we are looking at, and whether we favor it, don't favor it, whatever the case may be that way. Let me know if you have any questions on that. Also, I wanted to let people know, because there are a lot of questions on this, is about the fall LNR, Legislative and Research Committee. There will still be a fall LNR. We need to have that because of any resolutions that come in. So LNR is where they consider that for possible inclusion to the at the state annual convention, and for the membership as a whole to vote on future legislative items for us. And but the whole thing with Township Day at the Capitol was we wanted to expand it rather than have it just be LNR, which it had been in the past. We want to expand it. We're hoping to get a slew of people, and I think it's just going to take some time for people to understand that it's not LNR anymore. And this is truly everybody. We want to invite everybody there. We had almost 100 people there, which is more than what we usually do. I've looked at past events, and usually between 60 to 75 pre-pandemic that have gone there. So we did beat that, which is nice, but still woefully shy of where we like to be to really make a splash on people. So that's all I have for that. Heather, if you want to go ahead and answer the one question about MATIT, I'd appreciate it. Thank you.
Sure. So earlier this month, we sent out a letter that looks like this and talks about the fact that we were subject to an email compromise. What happened was, in the course and scope of going about business here at MATIT, I have people who I communicate with regularly, and I do so by multiple means. In this case, it was email. Somebody had gotten into our network and was watching this back and forth. The entity that I was communicating with was our reinsurer, and their email address is @alliant.com, ALLIANT. So whoever was watching changed that and registered a new domain. And so someone started communicating with me from ALLIANT.com, and getting multiple emails a day back and forth communicating. I did not catch that. And when we received a genuine invoice for our reinsurance, then they spoofed that, and from the spoofed domain sent me payment instructions for that very real invoice. And so, in accordance with the payment instructions, we sent out what turned out to be a misdirected payment, and that went out. When I reached back out to my genuine reinsurance broker and said, "Where's my policies? Where's my stuff? I've paid this." He informed me that he had not. And so I sent out this email chain to him and said, "Doug, I don't know what you're talking about. Here's where I paid you. Here's our back and forth." And it was at that time that he let me know that that was a misdirect. That was not them. I had paid someone else. That day, I got on the phone and tried to call the FBI, and there is no FBI number. So I went online and I filled out what they have. It's called an IC3 complaint. And so I filled that out and, waited to hear back from them. A couple of days went by and I didn't hear back. So then I reached out to the authorities here in St. Michael, which is Wright County. And we got Wright County involved. Their sheriff was immensely helpful. Their deputies were, just the best. And they are in the process of tracking that down. The good news is they've tracked down who done it. The bad news is that we still are in the process of trying to, go through that investigation, get, whatever information we can, and find out who we can, hold accountable for this. Theoretically, the money may be gone. I don't know if we are going to be able to collect any of it, if we're going to be able to get any of it back. We did file an insurance claim with our business insurers over here we had cyber coverage, and they took a look at it, they investigated it, and they said that this was not a covered loss. So there is no money coming from insurance for this. As the situation develops, I will keep members posted. This is still an ongoing and active investigation that we are taking very seriously and looking into. And we've given you everything that we have at this time.
Thank you, Heather. Appreciate that. Folks, I think it's important to note that this is a crime. This is a crime that occurred. This is happening all over the country, all over the world, and where these people are good at what they do. And they're funding whatever it is that whatever their agenda is and whatever they need dollars for. And they're not novices at this. And but as Heather said, we are the investigation is still ongoing. We have gone into and taken measures to help mitigate this possibility of occurring in the future. And so note that we have gone to great lengths to educate ourselves more on this. And the trust is very solvent. There are no issues with that whatsoever, and you are safe, and all your items are insured, and you are absolutely fine. Should you have a loss, we will be able to cover it. So please don't think anything different of that. And but thank you, Heather. I appreciate that. Any other questions from anybody about anything, this or anything else?
Hey, Jeff, Kevin Stromberg, Spencer Township, Aiken County. That's a good segue for one thing I wanted to ask about. My clerk brought to my attention this morning, getting inundated, her words, not mine, but from a lot of emails, phishing emails, that sort of thing. And she sent me a couple of them this morning. They are pretty sophisticated, that they're not that Nicaraguan type thing or full of misspellings and obvious things that they're a phishing attempt.
Right.
They're nice and clean, and they're a valid email that they come on that you could actually return to, although they're Hotmails. And they carry a file, which I assume carries a payload. They're labeled as PDF files, but they're not. They're labeled as remittance or project bid, that sort of thing. But they're all HTML or SHTML files that I assume would, if we're open on one of our township computers, would leave us susceptible to being hacked, steal our bank account information, all that sort of thing.
Correct.
But other than education, I know you guys have made some education things. Are we looking at a policy from MATIT for 1,700 townships that don't have any sort of IT support of our own?
Right.
How we should look at, or how we should handle, other than whatever each supervisor dreams up to go forward and, contact the county sheriff, which I know is not really going to be very supportive of us. I'm sure they see this sort of thing all the time and hard to trace back. But is there any thought been given to that, Jeff?
Actually, yes, I appreciate you asking that, Kevin. I am looking into ways to not only educate my office and our directors, but also ways that we can bring this out to the masses, to all of our townships, all 1,780 of them, to help you educate yourselves in that, and just to take some precautions. I know, especially with our smaller townships, a lot of times when you go into things of this nature, it costs money, and to me, I think it's a well worth investment, but I also know that there are limitations with some of our townships, so I want to be cognizant of that. So we are looking to see what we can bring out in mass to others, whether it just be more education or whether it be an actual program that can be for those who do have the funds that they can put into a program. Hopefully we can offer that to you as well. It would just be a pass through. It wouldn't be anything directly from us. We're not IT. I'm sure you know that. But once I do some vetting of other outside vendors, and but we can offer that as a potential, kind of point you in that direction if you want to go with that. This is somebody who we recommend. It'd be on that order. It wouldn't be anything that we would bill you for. It'd be a separate deal.
Great, thanks, Jeff. I'm just interested in how pervasive this is amongst all our townships. I assume it's easy to find our information. It's easy to find our emails. Easy to target, the clerks there, because there's going to be differing levels of IT knowledge, and happenstance somebody's going to click into this and run into some real problems, I'm sure.
Absolutely. What I'm hoping to do, at least for starters, is to take advantage of MATU, and all of you have free. And it's one thing. Actually, I didn't mention that. So remember about MATU. If you guys have not signed up for it, please do so. And we do have videos on there, and we have a slow going right now and trying to get new content on there, but we do hope to rectify that in the near future. But please go on there, and once we find out again, vet that particular company, I want to get some videos out there for all of you townships to at least use that as as a potential jumping off point into your education on it. But I appreciate the question, Kevin. Anything else? You either unmute yourself or write it in the chat. See, Pat. Oh, Pat says, is anyone else getting messages from someone claiming to be connected to SAM's, saying that our number is due to expire? They all have all my correct numbers, but they are not from SAMS.gov. I'm wondering, is Nicole on here? Nicole is our ARPA and SAMS.gov guru. And I don't see her on here. Oh,
She's
there's
on there.
there, Jeff. Hey, Nicole.
I'm here. Hi.
All the way through. Can you help out with that one, Nicole?
Yeah, actually, that's very common for townships to receive emails or phone calls from third parties that claim to be SAM, and it's usually a .com email address because SAM is .gov. So if you do receive any emails or phone calls from anyone trying to say that you can pay them to renew your registration. Registration for SAM is free. So at no time would SAM ever charge anybody to renew. And the other thing is no one can renew it for you because only an account administrator on the account can renew it. So I told people that they can delete those. They can report them to sam.gov if they feel the need to. But one thing I will say is when you do renew, there is an option to not make your township public. And I would strongly recommend townships maybe select not making it public, because then these third parties don't know when you're going to be expiring, so they won't pounce on you to renew your registration. So they won't have that information. And it's just a simple unchecking that box when you renew your registration so that you're not public anymore. But the good news is that because board members have to board members have to approve payment on items at their meetings. Most of the time, if they bring this up, they say, no, we don't pay to renew sam.gov, and they'll ask us as well. So if you guys need any reassurance, if it's a sam.gov or a third party trying to get you to pay for the renewal, you can just reach out to me and I can let you know right away what it is, if it's legitimate or not. Sam.gov will also never call you. They will only send you an email, usually a few months before your registration is due for expiration. And then they give you a process on what to do. They will never ask for payment. And it even says that in that email. It says it's free. So if anyone has any other questions, they can just email me.
Great. Thanks, Nicole. Appreciate that. Pat, I hope that answers your question. If anyone's looking in the chat, Diane had written in there saying that if anyone has had experience with fraud, please call your sheriff department. They were hacked and Stearns County was very helpful with the fraud. They even contacted the San Francisco, California to find the perp. And so, that's awesome. I'm glad that they were successful in getting that for you. Any other questions at all? All right, well, hey, everyone, thank you very much for joining us. We really appreciate that as always. Stay tuned. The first Tuesday in March, we'll be back and look forward to seeing you then. Take care, everyone. Enjoy the snowfall.